Okay, I'm about partnerships and limited liability companies. Part 1, formation and management of a corporation. Formation of a general partnership definition. A partnership is an association of two or more persons to carry on as co-owners a business for profit. It's formed as soon as that happens, regardless of whether the parties subjectively intended to form a partnership. A person may be an individual, trust, corporation, partnership, or other entity. Proof of partnership existence. Again, subjective intent is irrelevant. Since no formalities are required to form a partnership, it's sometimes difficult to determine whether the relationship between the parties is a partnership or something else. To determine whether a partnership exists, courts generally look to the intent of the parties. If they intended to carry on a business as co-owners, there is a partnership even if they did not subjectively intend to be partners. Just like perusing these test tips. The one is just circular reasoning. B, factors for deciding whether partnership exists, whether the party's intent is uncertain. Courts consider the following rules. Sharing of profits raises a presumption of a partnership. For the most important factor in deciding whether an association rises to the level of a partnership is the sharing of profits. Sharing of profits raises a presumption of partnership unless the share was received as payment of a debt, as wages or compensation for services rendered, as rent payment, as an annuity or other retirement benefit, as interest on a loan, or for the sale of goodwill of a business. Skipping hypos. Right to participate in control. Another important factor is the partnership inquiry is the person's right to participate in the control of the business, even if control is never actually exercised. To state that partners are co-owners of a business is to state that they each have the power to control the business. A Reputable presumption. There is if there is profit sharing and therefore a presumption of partner status, one can try to rebut the presumption with evidence suggesting the lack of a co-ownership interest, such as no right to control or no sharing of losses, something that owners would typically share. Evidence indicative of partnership. The following factors may be additional evidence that a partnership has been formed. However, in contrast to the sharing of profits, these factors do not raise a presumption of partnership. Title to property is held in joint tenancy or in common. 2, the parties designate their relationship as partnership. 3, the venture undertaken by the parties requires extensive activity. For example, A and B each contribute $100,000 to pay a building of rental to buy a building of rental apartments that must be managed. It is more likely that they are partners than if they had each contributed $100,000 to buy shares in a company that manages real estate. And 4th, sharing of gross returns. There's a exam tip again. Rights of parties among themselves or about the liabilities of the parties for obligations of the business. In such a question, you must determine whether there is a partnership. Do this by considering and discussing the factors above. Remember that the sharing of profits generally raises a presumption of partnership, but the presumption can be refuted by other factors indicating a partnership was not intended. Okay, writing. No writing is required to form a partnership. However, because of the statute of frauds, if partners wish to have an enforceable agreement to remain partners for more than 1 year, they generally must execute a writing reflecting the agreement. And partnership by estoppel. If no partnership was formed in fact, parties may still be liable as if they were partners to protect reasonable reliance by third parties. A. Liability of person held out as partner. When a person by words or conduct represents himself as a partner or consents to being represented by another as a partner, he will be liable to third parties who extend credit to the actual or apparent partnership in reliance on the representation. Within this section, there's no duty to deny partnership. Note that a person held out by another as a partner is not liable as a partner unless they actually consent to the holding out. Mere failure to deny a representation of partnership does not give rise to liability as a purported partner. Part B, liability of person who holds another out as partner. When a person holds another out as partner, he thereby makes that person his agent to bind him to third parties. If there is a partnership, only those partners who know of or consent to this holding out will be bound. Partnership agreement. No agreement is required to form a partnership. Nevertheless, you should be on the lookout for the existence of a partnership agreement because partnership law allows the partners to contract around almost all of the statutory provisions. Look for an agreement first and then fall back on the statutory default rules in the absence of an agreement. Note that a partnership agreement may be written, oral, or implied, for example, by conduct. Entity status with respect to parties' personal liability for partnership obligations. A partnership is a legal entity distinct from its partners. Title to land may be in the partnership's name. A partnership may sue or be sued in the partnership's name. Additional formation considerations include capacity, legality of purpose, consent, statement of partnership authority. Capacity. Anyone who is capable of entering into a binding contract may be a partner. A would-be partner who lacks capacity is liable only to the extent of his capital contribution, but the partnership with such person is not void. It will continue to exist until steps are taken to dissolve it. Legality of purpose. Let's make this bigger. A partnership formed to achieve an illegal purpose is void, and the courts would not compel an accounting or settlement of a void partnership's affairs. Consent, unless otherwise agreed, no one can become a partner without the express or implied consent of all partners. In fourth, statement of partnership authority. A partnership may choose to file a statement of partnership authority with the Secretary of State, which can give constructive knowledge of the extent of the partner's authority with regard to the partnership. Governing law. Generally, the RUPA, Revised Uniform Partnership Act, provides a default set of rules. Partners are free to agree through a partnership agreement to abide by different rules for governing the relationships among themselves, and the RUPA will govern only those issues not provided for in the partnership agreement. Note, however, that certain RUPA provisions cannot be waived. For example, the duty of loyalty, the right of a court to expel a partner. Those are just examples, not an exclusive list. Okay, the second major part after formation is management and operation of a general partnership. Number one, voting. Unless otherwise agreed, the partners have equal rights in the management of the business and equal votes. That is, one partner, one vote. Decisions regarding matters within the ordinary course of a partnership's business require a majority vote of the partners. Matters outside of the ordinary course of business require a unanimous consent of all partners. Number two, no right to salary or other compensation. Unless otherwise agreed, a partner has no right to compensation for services rendered to the partnership, with the exception of a right to reasonable compensation for services rendered in winding up the business. Partnership business. On the other hand, if a partner has impliedly or expressly promised to devote time to the partnership business and fails to do so, they may be charged in an accounting for damages caused to the partnership. Partners' accounts. Number 3, each partner is deemed to have an account that is credited with the amount equal to the partner's contribution plus his share of any profits and debited with the partner's share of any losses and partnership liabilities. Where a partner personally profits at the expense of the partnership must account to the partnership for those profits upon dissolution. A partner is entitled to settlement on their account. This is kind of like an owner's equity account. To use an accounting term. Number 4, indemnification and other repayment. A partnership must indemnify every partner with regard to payments made and obligations reasonably incurred in carrying on the partnership business. If a partner makes a payment or advance on behalf of the partnership beyond the contribution the partner agreed to make, the payment or advance constitutes a loan that must be repaid with interest. Number 5, books and information. Books and information must be kept at the partnership's chief executive office. Each partner has a right to inspect and copy the partnership books upon demand. Each partner must render true and full information of the things affecting the partnership. I love how they just say things. All things. Okay. Number 6, legal actions by and against partners. A partnership may sue or be sued in its own name. However, to reach a partner's personal assets, there must be a judgment against the individual partner. A partnership may sue a partner for breach of the partnership agreement or of a duty owed to the partnership. A partner may sue the partnership for other partners to enforce a right created by partnership act or agreement or a right otherwise belonging to the partner. Rights of partners is a table at the bottom of this page. It discusses management, distributions, remuneration, indemnification, contribution, inspection, and lawsuits. Management. All partners have an equal right to participate in the management of the partnership unless the partnership agreement provides otherwise. Distributions. Partners have whatever rights are granted in the partnership agreement as to distributions and profits. If the agreement is silent, partners share profits and losses equally. Remuneration. Partners have no right to remuneration for their services to the partnership except for winding up the partnership business. Indemnification. A partner has a right to be indemnified by fellow partners for expenses incurred on behalf of the partnership. Contribution. A partner has a right to contribution from fellow partners where the partner has paid more than his share of partnership liability. Inspection. A partner has a right to inspect and copy the partnership books. Generally, a partner may sue his partnership and the partnership may sue a partner in an action at law or in equity. So, snap a picture of this table of, I want to say, just, what do they call these? General rule or default rules under VUPA. No. When there isn't a partnership agreement stating otherwise, let's say. So now we're in part 2, financial rights and obligations of liability and liability. Financial rights and obligations and liability. Part 1 or 2.1, sharing profits and losses. Unless otherwise agreed, profits are shared equally among the partners by number. Unless otherwise agreed, losses are shared in the same manner as profits. Liability to third parties. This is section 2.2. The RUPA generally provides that each partner is an agent of the partnership for the purposes of its business. The authority of a partner to bind the partnership when dealing with third parties roughly follows agency law. Liability of a partnership in tort. With respect to the partnership's liability in tort, a partnership is liable for loss or injury caused to a person as a result of the tortious conduct of a partner or an employee acting in the ordinary course of business of the partnership or with authority of the partnership. 2.2.2 Liability of the partnership in contract. With respect to the partnership's liability in contract, a partnership is liable for all contracts entered into by a partner in the scope of partnership business or with actual or apparent authority in the partnership. Actual authority. Actual authority is the authority a partner reasonably believes they have based on communications between the partnership and the partner. It can come from the partnership agreement or a vote of the partners. A majority vote of the partners is required to authorize ordinary business. And a unanimous vote of the partners is required to authorize extraordinary acts. Statement of partnership authority. Actual authority can also be created by the partnership's filing of a statement of partnership authority with the Secretary of State. For real property transfers, this must also be filed with the county recorder. A statement of authority grants or limits a partner's authority to enter into transactions on behalf of the partnership. The effect differs depending on whether the transaction involves a transfer of real property. Transactions involving real property. Grants of and restrictions on partner authority to transfer partnership real property in the statement are binding on third parties if the statement is also recorded in the county where the property is located. In other words, third parties are deemed to have constructive knowledge of the statement if Secretary of State and county filings are made. Third parties are benefited by filed grants of authority unless they have actual knowledge that the partner lacked authority, and burdened by filed restrictions on authority. Transactions not involving real property. With respect to all other transactions of a partnership other than real property transfers, grants of partner authority in the statement are binding on the partnership unless the third party has actual knowledge that the partner lacked authority. Restrictions on partner authority in the statement, however, are not binding on third parties. In other words, third parties are deemed to have constructive knowledge only of filed grants of authority, not filed restrictions. Third parties are benefited by filed grants unless they have actual knowledge that the partner lacked authority and are not burdened by filed restrictions. Only actual knowledge of restrictions burden them. Apparent authority. The RUPA provides that a partner is an agent of the partnership and that a partner has apparent authority to bind the partnership to transactions within the ordinary course of the partnership's business or business of the kind carried out by the partnership unless the third party is aware that the party lacks actual authority to act. It is very important to remember that the agents of the partnership, partners have apparent authority to bind the partnership to any contract within the scope of the partnership's business. If the contract is outside the scope of the partnership's business, the partnership generally will not be bound unless the partner has actual authority. Business of the kind. Note that apparent authority is not merely limited to transactions that are in fact within the ordinary course of business for the partnership in question, but extends only to transactions that would apparently be for carrying on business of the kind by the partnership. Limitation, knowledge, or notification. A partnership will not be bound by the partner's act if the partner lacked actual authority and the person with whom the partner dealt either knew or received notification of such fact. Knowledge. Under RUPA, knowledge means subjective knowledge. What the person actually knew, what the person should have known based on circumstances is irrelevant. Notification. Under the RUPA, a notification is effective either when it comes to the person's attention or when it is duly delivered. Thus, if a notification limiting a partner's authority is duly delivered to a third party, for example, at the third party's place of business, the party can The third party cannot rely on apparent authority with regard to the limitation, even if the third party has not actually read the notification. Transfers of partnership property. Partnership interest indicated. Any partner may transfer property held in the name of the partnership. If partnership property is held in the name of one or more partners who are identified as such, but the partnership is not named, transfer by the title holders in their own names is effective. In either case, if the transferring partner lacked authority, the partnership may recover the property from the initial transferee, but not from a subsequent bona fide purchaser. Partnership interest not indicated. If the partnership's interest is not indicated in the instrument transferring the property, the transfer may be made by those in whose names the property is held. If the transferee gives value without notice of lack of authority, they take free of the partnership interest. So I keep getting these emails and making me curious. What's going on? Alright, where was I? I was at the end of this page. 2.2.3 Liability of the partners. A defining characteristic of the general partnership is that each partner is jointly and severally liable, so one or more partners may be sued for all obligations of the partnership, whether arising in tort or contract. But the plaintiff must first exhaust partnership resources before seeking to collect from an individual partner's assets. So the partners are essentially guarantors. That means a plaintiff must first try to recover from the partnership's assets before seeking to recover from your personal assets. A judgment is not personally binding on a partner unless they have been served and the creditor has exhausted partnership assets, or exhaustion is excused by agreement or court order, or because the partnership is bankrupt. So let's just take a couple notes. I'm going to forget some of these terminology. Get some of the terminology. This is an exhaustion rule, even though they're not calling it that. So I'm writing down they're referring to them as guarantors. I realize this is actually kind of difficult to discuss in an essay, because it's not so specific as to say whether or not the judgment has to have both names of the partners. And so walking around that issue is kind of complicated when you're trying to say, talk about the exhaustion rule. And also balancing joint and several liability. Because it just sounds like he could be held liable for joint liability, joint and several liability, that the exhaustion rule is not going to be considered until after you've paid on that. So I don't know. It's hard to discuss. Dancing around the issue. Like, we don't need to know how these actions are actually brought and satisfied. I feel as though there's another nice word that I wanted to write down. So on page 14 of 41, that's not weird. Business of the kind. We're talking about the basic authority principles. This is so weird. Okay, let's look at their voting. How are they voting? What's the general rule on their voting? Don't write that anywhere. I want to start with voting. Vote. Okay, here we go. General rule: majority vote is sufficient when a decision is within the ordinary course of partnerships business or business of the kind perfect. Now here unanimous votes required when make it really hard to find. Unanimous. Extraordinary acts. Okay, shouldn't have that. Required to authorize extraordinary acts. Okay. What comes to me within the actual notice section? Either way, back to page 14 where we were. 14 of 41. We're talking about liability partners. We said how it's like not really hitting the issue dead on as to how to bring a judgment. Each partner is personally and individually liable for the entire amount of partnership obligations. So where one partner pays the whole obligation of the partnership, they're entitled to indemnification from the partnership. They may also require the other parties to contribute to their pro rata shares of the payment if the partnership is unable to indemnify. 2.2.5, limiting liability to third parties. There's literally just a hypo in this section. Partners cannot limit a third party's rights without the third party's consent. The agreement is effective, however, among the partners themselves. Okay, I remember this. So the parties agree themselves that one of them will not be subject to liability, but that doesn't matter as it pertains to a third party bringing an action against that party. A party can just later on recover from the other partners. Now, 2.2.6, liabilities of admitted partners. If the partnership admits a new partner, unless otherwise agreed, this requires a unanimous partner vote. That is that partner liable for debts incurred by the partnership before their admission? A newly admitted partner is not personally liable for partnership obligations that arose before their admission. They can only lose the amount of the investment in the partnership. The liability of withdrawing disassociating partners is discussed in Module 4. 2.2.7, liabilities of disassociating partners. An outgoing or disassociated partner remains liable for obligations arising while they were a partner unless there has been payment, release, or novation An outgoing partner can also be liable for acts done after disassociation and the liability of disassociating partners is discussed more in Module 4. So the test tip just repeated everything they just said. 2.2.8, criminal liability. Partners will not be criminally liable for the crimes of other partners committed within the scope of the partnership business unless the other partners participated in the commission of the crime, either as principals or accessories. Notice under the RUPA, a partner has notice of a fact when the partner has actual notice of the fact. And 2 is notified of the fact. Or 3 has reason to know the fact based on the surrounding circumstances. A, when notification effective. Notification is effective not only if and when it comes to a partner's attention, but also when it is delivered to a place of business held out by the partner as a place for receiving communications. Notice imputed to the partnership. A partner's notice of a fact relating to the partnership is imputed to the partnership immediately unless the partner having notice is participating in fraud against the partnership. So quickly, let's kind of write down those 3 what look like criteria for imputing knowledge. Actual knowledge, notified of the fact, reason to know, and where do you put it? Like, aren't we within the dissolution section? So, what type of notice are we talking about? This is just so weird. I think we're talking about disassociation. Okay, we're within the disassociation section. And am I wrong? Oh, we were. Maybe it hasn't been sectioned off like that. Fiduciary duties and property issues is the next section. All right, so I'm actually going to just write this in the margin of my issue spotting checklist. There's business of a kind. It's already in here. I think this is good. All right. So, imputation of knowledge. No idea where this is supposed to actually go, or why it would be relevant. But it requires 3 things, right? 1, 2, and 3. Actual knowledge. Notified of the fact. And lastly, reason to know the fact based on surrounding circumstances. Okay, so now we're going to fiduciary kind of duties. Wait, are they really fiduciary? I think so, as to each other. Slow, any slowly. Yeah, because the first thing it says is fiduciary responsibilities. fiduciary duties and property issues. Fiduciary duties. Each partner owes 4 duties to the partnership. They owe duties of loyalty and care to each other. And to the partnership, they owe a statutory duty of disclosure as well as duty of obedience. Duty of loyalty. This duty requires each partner, 1, account to the partnership for any benefit derived by the partner in conducting the partnership business, using the partnership's property, or appropriating a partnership opportunity. 2, to refrain from dealing with the partnership in the conduct of its business as or on behalf of a party having an interest adverse to the partnership. And 3, to refrain from competing with the partnership in the conduct of its business. So those are the 3 things that make up loyalty. So 1, you're going to account to the partnership. Benefits arising from partnership, property, opportunity. 2, just like this adverse interest. And then 3, not to compete. Duty of care requires each partner to refrain from engaging in grossly negligent or reckless conduct, intentional misconduct, or a knowing violation of law. Negligence. Recklessness. Intentional misconduct. Or violate a law knowingly. Duty of disclosure. A partner also has a duty to provide complete and accurate information concerning the partnership. The duty of disclosure is a statutory duty rather than a fiduciary one, although some judicial opinions treat it as fiduciary in nature. RUPA provides that each partner and the partnership shall furnish to a partner without demand any information regarding the partnership's business and affairs reasonably required for the proper exercise of the partner's rights and duties, and 2, on demand, any other information concerning the partnership's business and affairs, except to the extent the demand or the information demanded is unreasonable or otherwise improper under the circumstances. Duty of obedience requires a partner to obey all reasonable directions of the partnership and not act outside the scope of his or her authority. All right. Elimination of duties. A partnership agreement may not eliminate the duties of loyalty and care. The duty of disclosure may be eliminated. Property issues. 3.2 classification. 3.2.1 partnership capital. Partnership capital is the property or money contributed by each partner for the purpose of carrying on the partnership's business. Partnership property in its broadest sense is everything the partnership owns, including both capital and property subsequently acquired in partnership transactions. Rules for determining partnership property. Which property belongs to the partnership and which belongs to an individual partner. There's no restriction on what may be partnership property, and sometimes it's not always obvious whether property is partnership property or the individual property of a partner. The RUPA has a number of provisions concerning ownership of titled property, both titled personal property and real property. For property that is not titled, the common law has developed a number of criteria to analyze. A. Property deemed to be partnership property. Titled property is partnership property if it is acquired in the partnership's name or in the partnership's name where it is apparent from the document that they are acting for a partnership. For instance, it says partnership or partner. Property presumed in title license. Property presumed to be partnership property. Under the RUPA, property is reputably presumed to be partnership property if it was purchased with partnership funds, regardless of whose name title is held. Partnership funds includes not only the partnership's cash, but also the partnership's credit. And C, property presumed to be the partner's separate property. Under the RUPA, property is reputably presumed to be a partner's property if 1, it is held in the name of one or more partners. The instrument transferring title gives no sign they are acting for a partnership, and 3, partnership funds were not used to acquire the property. Untitled property, common law criteria, in cases not governed by the explicit RUPA. Okay. FYI, this is in my outline. So for titled property, property deemed to be partnership property. What did it really say? It has like a by title. This one didn't have a reputable presumption. But it's presumed when it's purchased by partnership funds. Property presumed to be partner's separate property when purchased by separate property. All right, that's about it. And title. Doesn't indicate a partnership. Entitled property. I thought this was going to be longer, this section. Common law criteria in cases not covered. Okay, it is long. In cases not covered by the explicit RUPA provisions, for example, in cases of property that is not titled, in determining whether property is partnership property or the separate property of a partner, courts will probably continue to look to the following common law criteria, which tend to indicate that the property was intended to be partnership property. So the factors suggesting partnership property is going to be acquisition with partnership funds, use of the property by the partnership in conducting the partnership's business, entry of the property in the partnership's books, a close relationship between the property and the business operations of the partnership, improvement of the property with partnership funds. And maintenance of the property with partnership funds. Next page, maybe there's more, there isn't, but there's a graph, how to determine whether property is partnership property under the RUPA. And it's a decision tree. Okay, rights of partnership property, the partnership rights. The partnership rights and partnership property are totally unrestricted. A partner's rights. A partner is not a co-owner of a partnership property and has no interest in partnership property which can be transferred. The partnership is an entity. The partnership itself, not the partners, owns the property. A partner can simply use partnership property for partnership purposes. The partner's ownership interest in the property. A partner's ownership interest in a partnership is called the partnership interest, just like a shareholder's ownership interest in a corporation is called stock. The partnership interest is the personal property of the partner. Although it is personal property, there are restrictions on what a partner can do with it. A, comprised of management rights and financial rights. A partnership interest is comprised of 1, management rights, that is, a partner's right to participate in the management of the business, to obtain information about the partnership. And to be recognized as a partner. And 2, financial rights, that is, a partner's right to receive his share of any profit distributions made by the partnership. B, no unilateral transfer of management's rights. Unless otherwise agreed, a partner cannot unilaterally transfer his management rights and thereby make the transferee a partner. The default rule for the admission of new partners is that it requires unanimous vote of the existing partners. Unilateral transfer of financial rights permitted. Unless otherwise agreed, a partner can unilaterally transfer his financial rights. The transferee merely has the right to receive profit distributions from the partnership that would have otherwise gone to the partner. The transferee is not a partner. The transferor is still a partner and retains all of the management rights of a partner. That's my finish. All right. Let's get the hypo. And the notes. You're going to go, disassociation and dissolution of a partnership. So now we're truly in disassociation. How many more pages do we have before we talk about limited liability partnerships? Right? Why do I ask? So let's take a break after that. There we go. It's going to take a break on page 32. And right now we're on page 22. No, we're on page 24. 8 more pages of dissolution and Disassociation and dissolution of a partnership. 4.1 Disassociation. Disassociation is a change in a relationship of the partners caused by any partner ceasing to be associated in the carrying on of the business. Disassociation of a partner does not necessarily cause a dissolution and winding up a partnership business. The term simply refers to withdrawal. When a partner disassociates from a relationship, the partner withdraws or bows out of the partnership. Events of disassociation. A partner becomes disassociated with the partnership by oral or written notice of the partner's express will to withdraw, happening of an agreed upon event, valid expulsion of the partner for the partner's bankruptcy, or the appointment of a receivership for the partner's death or incapacity to perform partnership duties, decision by the court that the partner is incapable of performing the partner's duties, or termination of the business entity that is a partner. Okay, so all of these things actually should be written down. Events causing dissolution. There are 7. So first there's oral or written notice. There's happening of the event. There's valid expulsion. There's bankruptcy, appointment of receiver. There's death or incapacity. There's a court decision on, it's kind of capacity, but it's capability to perform. And then there's lastly the termination of the business entity that is a partner. Wrongful disassociation. A partner will be deemed to have wrongfully disassociated with if the disassociation is in breach of an express term in the partnership agreement. A disassociation is also wrongful in a term partnership if the partner withdraws, is expelled, or becomes bankrupt before the end of the term. A partner who wrongfully disassociates is liable to the partnership for any damages caused by the disassociation. At-will partnership. An at-will partnership is one where the partners have not agreed to remain partners until the expiration of a definite term or the completion of a particular undertaking. It is the default form of partnership. Most partnerships are at-will. Term partnership. Term partnership is the converse. It is a partnership where the partners have agreed explicitly or implicitly to remain partners for a definite term or until the completion of a particular undertaking. So this is at will. Whatever, I'm going to say for particular undertaking. And then what's the other one? Oh, wait, these are at-will partnership. This one's term partnership. And there's not a third. There isn't. Okay. consequences for disassociation for partnership. When a partner disassociates from a partnership, one of two statutory avenues is implicated. The first avenue provides that a partnership is dissolved and that its business must be wound up. This means that the partnership business will be liquidated, that is, sold off. The second avenue provides that the partnership continues in existence with the disassociated partner becoming entitled to a buyout of the partnership interest. The nature of the event of disassociation dictates which of these avenues is implicated, whether it's a liquidation or a buyout. Where does that get written down? Oh. I am in dissolution. Stop writing notes in the wrong place. Oh my goodness. It doesn't really matter. Consequences of a disassociation. Here we go. We've got a liquidation or a buyout. Now what? For a partner, upon a partner's disassociation, their right to participate in management ceases. The partnership must buy out their interest at either liquidation or going concern value and must indemnify against the known pre-disassociation liabilities as well as against post-disassociation liabilities not incurred by the dissociating partner's acts. However, a partner who wrongfully disassociates before the expiration of the partnership term or completion of a particular undertaking is not entitled to payment of the buyout price until the term expires or the undertaking is completed unless they can establish that earlier payment will not cause undue hardship to the partnership's business. Interest must be paid on the buyout price from the date of disassociation to the date of payment. I vaguely recall that this could be reduced by costs incurred by the wrongful disassociation. But I'm just going to write may be stalled until particular undertaking, unless without undue hardship. Just writing that in the margin. Dissolution. Dissolution and winding up are required only in limited circumstances. For example, event in agreement requiring winding up. Business becomes a legal issuance of a judicial decree, unanimous consent of the partners in a term partnership, expiration of the term partnership. Two circumstances are of particular importance. In general, when a partner disassociates by express will in an at-will partnership, the partnership is dissolved and its business must be wound up. In a term partnership, if one partner disassociates wrongfully, or if a disassociation occurs because of the partner's death or bankruptcy, dissolution and winding up of the partnership are required only if, within 90 days after the disassociation, at least one half of the remaining partners agree to wind up the partnership. So, let's see. All right, so at will requires dissolution. If term dissolution not required unless within 90 days, remaining partners. I'm just going to write agree. Buyout and continuation of the business. If a partner's disassociation does not result in a dissolution and winding up, the partner is entitled to receive a buyout of his partnership interest. The remaining partners may continue the business. If the dissociation is wrongful, any damages will be offset against the buyout price. Liability of disassociated partner. Pre-disassociation. Generally, a disassociated partner remains liable for pre-disassociation partnership obligations. The creditor can agree to release the withdrawing partner, however, no specific obligations. Post-disassociation, a dissociated partner can be liable for post-disassociation partnership liabilities incurred within 2 years after dissociation, assuming that disassociation has not occurred. If 1, when entering the disassociation, the other party reasonably believed that the disassociated partner was still a partner, and 2, did not have notice of the partner's disassociation. Note that a disassociated partner can protect themselves, meaning cut short this period of liability by notifying creditors directly of their disassociation effective immediately, or by filing a public notice of disassociation, which becomes effective 90 days after filing. The partnership can make the filing as well. Disassociated partner's power to bind partnership. Apparent authority of disassociated partner. A partnership can be bound by an act of a disassociated partner undertaken within. I think I just read that. All right. Dissolution. Unlike disassociation, dissolution generally requires the partnership business to be wound up. When dissolution and winding up occur, partnership assets must be applied to the discharge of partnership liabilities. If the assets are insufficient, individual partners are required to contribute, pay in accordance with their lost shares. If there are excess assets, they are distributable to the partners in cash in accordance with the profit shares. Dissolution of a partnership at will. When a partnership is formed with no particular undertaking or definite term, it is said to be a partnership at will. A partnership at will can be dissolved at any time by the express will. For example, notice of dissolution of any partner without penalty. 4.2.2, events causing dissolution. The following events trigger dissolution under RUPA. In a partnership at will, notification by any partner of an express will to withdraw as a partner. In a partnership for a definite term or particular undertaking. Expiration of the term or completion of the undertaking, consent of all partners to dissolve, or 3, within 90 days after a partner's death, bankruptcy, or wrongful disassociation, at least half of the remaining partners wish to resolve. more pages. C, the happening of an event agreed in the partnership agreement that requires winding up of the partnership business, the happening of an event that makes it unlawful for the partnership to continue, issuance of a judicial decree on application by a partner that, 1, the economic purpose of the partnership is likely to be frustrated, 2, a partner has engaged in conduct making it not reasonably practicable to carry on the business, or 3, the business cannot practicably be carried on in conformity with the partnership agreement. And last on this page, issuance of a judicial decree on application by a transferee of the partner's interest that it is equitable to wind up the partnership, 1, after the term expires or undertaking is completed in a partnership for a definite term or particular undertaking, or 2, at any time in a partnership at will, and the passage of 90 consecutive days during which the partnership does not have at least 2 partners. I feel like everything on that page probably should be written in here. I'm just going to write C, page 28 of CNR. It's probably written in here too, this outline I'm writing in. On page 18. So, priority of distribution. Each level of priority must be satisfied before beginning the next level. First, the partnership must pay all creditors. Creditors include outside creditors, for example, trade creditors, lenders, suppliers, and inside creditors, for example, partners who loan money. Second, the partnership must repay all capital contributions paid into the partnership by partners. Third, profits or losses, if any. Partnership continues after dissolution. The partnership continues to exist after dissolution until the partnership is wound up. Who may wind up? As a general rule, all living partners have a right to participate in the winding up of the partnership's business, except partners who have wrongfully dissolved the partnership and bankrupt partners. If all partners have died, the legal representative of the last surviving partner may wind up. 4.2.6, parent authority, partners' power to bind partnership after dissolution. Partners retain a parent authority to bind the partnership to a third party on new business, even after an event requiring winding up. A partnership can be bound after dissolution by any act of a partner appropriate for winding up the partnership's business. The partnership will also be liable for other acts if the party with whom the partner dealt did not have notice of the dissolution. The partnership can protect itself by notifying creditors directly of the dissolution, effective immediately. In addition, any partner who has not wrongfully disassociated may file a statement of dissolution with the Secretary of State. All persons are deemed to have notice of a dissolution 90 days after such a notice is filed. Partners may waive dissolution and continue the business. Anytime before winding up the business is complete, the partners may decide to waive the dissolution and continue the partnership by unanimous vote of the partners who have not wrongfully dissolved. Such waiver does not affect the rights of persons who have relied on the dissolution before receiving notice of the waiver. Alright, so this is going to mark the end of the general partnership section. And when we catch back up, we'll look at other forms, like limited liability partnerships, companies, limited liability limited partnerships, for example.